So she have to get it off here. Okay. Mr. Ham and Mr. West. Okay, so we try.
The DWI.
Okay. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. First of all, I'd like to apologize for you for sitting out into the hallway. We were taking care of some business in court, and so we're getting started just a little late. I read everyone's questionnaires that you filled out. This is one of our protocols that we have here at the Jefferson County Courthouse. And so we had to do that first. And the other thing is, should make you direct your attention to our monitors. I know you'll see a red light up there at the top, and it says live on YouTube. And because of our COVID protocols, the general public normally is not allowed to come into the courtroom because we only have a limited amount of space. But a defendant has a right to have all trials and proceedings in the public. And so since the public cannot come here, we go to the public, but through YouTube. And so the public has access through our YouTube channel. And so right now, this is being broadcasted on YouTube. And we're required to do that by the regulations and rules that was pronounced by the Texas Supreme Court and the Texas Court of Criminal Appeals. Now, ladies and gentlemen, you have been asked to come here for a jury trial and for you to serve on a jury. Now, our courtroom hours vary. They are normally from 9 a.m. in the morning to 5 p.m. in the evening. Whether you are selected as a juror today or not, you are performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate at recess, for meals, and at night. Now, I have an administrative matter that I must attend to before determining whether or not you are qualified as a juror. And so the first administrative matter that I must handle is to give each and every one of you the oath on our panel. And what I would need each of you to do is raise your right hand. And once I give you the oath, then at the end, you said, I do, and then you could put your hand down. So at this time, will everyone please raise your right hand? Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be pronounced or propounded to you by the court or under its direction, touching on your service, qualification as a juror, so help you God? Okay, you may put your hands down. Now, ladies and gentlemen of the jury, the law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service in a criminal trial. It is very important that you answer these questions truthfully. If you do not, the lawyers or if the lawyer or I discover that you have not answered the questions truthfully and you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, I'm going to ask you a series of questions, but I do not want you to answer out aloud. I want you to answer it to yourself. And once I finish asking you the last question, I will ask this: is anyone disqualified under the law? And if you think that you may be disqualified under the law based on your answers to any one of those questions, I'll ask you to raise your hand. And then once I ask you to raise your hand, we will ask you to come up and discuss the matter privately. And the reason why I say privately is because we have a noise device that we will put on, and we turn off the mics and we'll mute the YouTube, and we will discuss the matter. Okay, so I'm gonna ask you a series of questions. Please answer to yourself. And then at the end, when I ask if anyone is disqualified under the law, and I'll ask you to raise your hand, just raise your hand, then we'll ask you to come up one at a time. Excuse me. First question. Except for failure to register, are you a qualified voter in Jefferson County, state of Texas, under the Constitution and laws of Texas? Number two, have you ever been convicted of theft or any felony? Number three, are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Four. And I must ask this question, so I know when you hear it, don't take it personally. It's just a question that the law requires me to ask. Number five, are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Now, is anyone disqualified under the law? If you think that you may be disqualified, please raise your right hand. Let the record reflect that no one on the panel has raised their hands, and so therefore all of the panel is qualified. Now, I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to do so, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, please continue and remain seated. And I will ask these questions in the same manner that I asked the first series of questions. I'll ask the question, please answer to yourself. And at the end, I will ask if anyone think that if anyone would like to claim an exemption. And if you like to claim one of the following exemptions, then you'll just raise your right hand. And then we'll ask you to come up to the bench and we'll discuss the matter privately. Number one, are you over 70 years of age? Do you have legal custody of a child or children under the age of 12 years and jury service will necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher learning? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from Jefferson County and away from your home? Now, if any of these exemptions apply to you and you do not desire to serve as a juror, please raise your right hand. Okay, we got 2. And is that Brittany Brinson? That's 1. We go down. Brinson. Kenesha Barnes, that's the other one. Okay. Ms. Brinson, will you please come forward? Attorneys. we've already covered qualifications, exemptions. Now we will move to excuses. If any of you feel that there is a reason why you cannot sit as a juror, once I finish with the excuses, we're going to ask that you will come up to the bench so we could discuss it privately. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the state and without the consent of the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel that would like to claim an excuse? If you would like to claim an excuse, please raise your right hand and then we'll discuss the matter privately. Okay. We have number 5, that's Barbara Lewis, is that correct? And Barnell Dartez, is that correct? Okay. Ms. Lewis, would you please come forward? Okay, now, is there anyone else who'd like to claim an excuse or an exemption? And for the record, let the record reflect that no one has raised their hands. So, ladies and gentlemen of the panel, each and every one of you are qualified. You have not claimed any exemptions, nor you have claimed any excuses. The defendant in this case is Pamela Neal. And Ms. Neal is sitting at the table with her attorney, Mr. John West. And the state, in this case, is represented by Attorney Blake Ham and new assistant,
Tommy Coleman.
Mr. Coleman.
Good afternoon.
And the court reporter in this case is Ms. Carla Davis. Now, she will be taking down everything that is being said. So speak up when you are answering or asking questions. The bailiff in this case is Mr. Charlie Porter. The defendant stands charged by information with the Class B misdemeanor offense of driving while intoxicated. And this offense, the punishment range is minimum jail time of 72 hours to a maximum of 180 days in the county jail and a fine up to $2,000. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs, but are trying to select fair and impartial jurors to decide this particular case. If at any time you would prefer to not answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we can discuss it more privately. And we'll put our mics on mute and we'll play the noise device. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready to proceed?
Ready, Your Honor.
Sorry, Your Honor. Okay, apologies. Oh, Mr. Ham, the panel is yours. You need.
I'm just gonna plug this in real quick.
Okay, and we'll give each side 30 minutes, and the court will be keeping the time. You may proceed.
Thank you, Your Honor. Thank you, the remaining few who made it through the process and struggled here all day and waited. And it's like being on Survivor or something, although I don't think you're maybe winning a prize. My name's Blake Ham, as Judge Holmes told you, and along with Mr. Coleman, we represent the state of Texas, Jefferson County, represent the citizens of Jefferson County in this case. As the judge explained, it is a driving while intoxicated case. Mr. Coleman said that since we've been digging through your background forms and reading about your hobbies and life experiences, that I should tell you something about myself. So I'm Texan. I'm new to the Southeast Texas. Moved here in July. Police officer. Tried teaching school. I walked out of that in about 2 years. That's my job. Then I went to law school and practiced civil law for about 10 years. And in July, I had the good fortune to come to Jefferson County and work for this DA's office. So what are we doing? As you may have noticed, in a lot of ways, you might call this jury selection, but in most ways, it's more jury deselection. Right? We've already deselected quite a few people. The jury in this case is a misdemeanor case. Okay, Class A misdemeanors, Class B misdemeanors, not the felony cases that are tried over next door. All right, a jury over there is 12 people. The jury in this court is 6 plus an alternate. You're wondering, who will be the first 6 people in order who aren't deselected, okay? Plus 1 alternate, so 7 people will probably be sitting on the jury. The state and the defense each get 3 arbitrary strikes. Okay? Will be the first 7 people there. Now, I think as the judge explained to you, we're not trying to pick 7 good people or 7 just people, because how would we know, right? You don't know us, we don't know you. What we are trying to do is find the best 7 people to sit on this DWI trial. And that may be you, it may not be you. Ultimately, to be a juror to sit on this trial, you have to be somebody who can listen to the facts and follow the law. All right? But we all come in, bless you, we all come in with our own predispositions, our own experiences. Maybe you just can't decide a DWI trial fairly for some reason or another. We don't know, but that's what you're here to do. So voir dire, that's the French word for jury deselection, or it means speak the truth. Okay? So we're just asking you to speak the truth. So we can find 7 people who can listen to the facts, by law, and fairly determine the guilt risk. Okay. Also, in this case, I believe the defense has elected to have the jury not only decide guilt or innocence, but also the punishment. So we'll talk about that in a minute. All right, so what are we talking about? We're talking about driving while intoxicated. It's a statutory offense in Texas. All right, you commit the offense if you are operating a motor vehicle in a public place while you're intoxicated. I don't think, I could be wrong, I don't think we're going to be trying this case about whether or not the defendant was operating a motor vehicle or was in a public place. I think the trial is going to be about whether or not she was intoxicated when doing so. And I think that's going to be the main issue that the jury is going to have to decide. All right, again, what do we have to prove? The state. We just went through it. In Jefferson County, Texas, on or about July 29, Ms. Neal operated a motor vehicle in a public place. Wow, there's that word again, intoxicated. Okay. Statute was intoxicated means. By statute, intoxicated means, by the ingestion of alcohol or drug or dangerous drug, some other substance, you have lost the use, the normal use of your mental and physical faculties. Okay, so you can be intoxicated by, losing the normal use of your mental faculties by the introduction of alcohol or drugs, or you can have lost the use of your mental faculties, normal use, because you took a drug or drank alcohol, or if you had an alcohol concentration of 0.08 or higher. Okay, those are all various ways that you can prove intoxication. Okay, again, the judge told you about the punishment. So let me just ask this real quick. So for DWI, is there anybody here who doesn't think that they could consider, just asking you to consider the full range of punishment? And when I say consider, like if you're on the jury and you say guilty, right, if you were in this DWI trial, could you consider sentencing the defendant up to 6 months in jail and or a $2,000 fine? Or on the other hand, you consider just probation. So I guess what am I asking? Is there anybody here who doesn't think that they could at least consider one end of that range of punishment or another? Okay. I said, you don't have to give, 6 months in jail. It could be probation. You don't have to give probation. It could be 6 months in jail or anything in between. Okay, real quick. The burden of proof is on the state. We accept that. At this point in time, Ms. Neal is innocent. And no evidence presented to anybody. We haven't picked a jury, right? And no evidence presented at this point in time, Ms. Neal is innocent of the crime she's been charged with. And she's innocent unless we prove every element of that offense beyond a reasonable doubt. All right. So, has anybody here not seen Indiana Jones, Raiders of the Lost Ark? Everybody, okay. Raise your hand if you've seen Raiders of the Lost Ark. No, I have never seen it. Never seen it. All right, and Mr. Bigelow, you've never seen this movie?
No.
Oh, you saw it. Okay, I didn't say sorry. Okay, back in the back corner, Mr. Richard. Never seen this movie?
Yeah.
Oh, you have. Okay, great. Okay. Oh, you've never seen it. Okay, well, it's very exciting. It's a very fun movie. It's very exciting. So the hero is Indiana Jones, and he runs around archaeological sites and whatnot, finds treasures like the Lost Ark of the Covenant and whatnot. Usually chased by bad guys like Nazis or something. But in the first movie, he had a girlfriend. And why am I telling you this? Well, I'm trying to use this. I'm going to give you an example of something and ask you a few questions because we're talking about what does it mean to prove something beyond a reasonable doubt. All right. And so I'm going to ask you, if you think there's enough evidence to convict beyond a reasonable doubt, what does it mean? Right. So, and I'll tell you that the courts have told us that we can't define that term for you. Used to, we could define because that's what we have to prove the elements, right? Beyond a reasonable doubt. That's our burden. And it used to be the court said we can tell you a definition, but we can't tell you a definition anymore. We can't try to define it to you. So what we say is, utilize your common sense. You're going to see evidence if you're on the jury. It's going to come at you. You're going to see it. You're going to use your experiences, your viewpoint, your lens, and decide, well, I think she's guilty. Have they proved this beyond a reasonable doubt? Okay, so here's back to Indiana Jones. So Indiana has a girlfriend that he meets in the film called Mary. All right, and they get chased around a lot. And one time they're getting chased through this market by bad guys, Nazi sympathizers or something. And this dude grabs a knife and he comes after Marion. And Marion is running through this marketplace and she grabs a pan and then she runs into a dark hole. Right in there. You can't see in the door, it's black. You see Marion run in there with a pan. You see the guy with the knife chase her into the door, and then you hear the sound of a pan hitting something. And then the bad guy with the knife falls out of the door, he's unconscious, and Marion walks out with a pan. All right, so Mr. Alvarez, my question to you is this. If I was trying to convince you that Marion was guilty of hitting that bad guy with a pan, knocking him unconscious, if that's all the evidence you had, you saw that video, right? She runs in there, you hear the pan hit something, the guy falls out, and she walks out with a pan like this. Have I proven to you that she committed that offense beyond a reasonable doubt? Why not?
That's just what you see, but there's no proof beyond, what's in the dark. There's no light behind that to see who else was in there, if anybody else was coming out. So to me, it's not just, I can't just look at that clip and determine.
It wouldn't be enough for you.
Correct.
Okay, what would you want? What do you need to convict Marion?
If she hit the guy with
Yes, I say she hit the guy with the pan.
just more information, more detailed information to determine.
More detailed information, like maybe an eyewitness. Okay, but it was dark and there wasn't an eyewitness.
It could have been somebody there before that, to see if somebody else went in there.
Maybe an admission. Something like that. Okay. Ms. Johnson, what do you think? Do you think we've proven our case?
I think that, if she's being chased by someone with a knife and she has, a pan in her hand and she goes into the room, like you say, I think that there's, a good chance that she hit him over the head with a pan.
Okay, fair enough. I think it's like common sense.
Using my context clues.
Right, she's not denying it. Mr. Bigelow, you think the state's proven its case against Marion?
I would feel like you have to. She ran in there, she ran in the dark place,
She went in with the pan.
and then he came in.
He chased her.
Did she have a pan when she went?
She walked, you see her run in that door with a pan.
Okay.
The guy chases her with a knife.
Uh-huh.
You hear the bang. You see the dude fall out of the door, and then she walks out with a pan like that. That's what you see.
I'd have to go with that. I'd have to go with what I said.
Okay, fair enough. I got you. All right, let's see. That's right. What do you think?
More likely than not, she did it.
Is it just more likely than not, or do you think we've proven it beyond a reasonable doubt?
To me, beyond a reasonable doubt is more likely than not.
Okay, I got you. All right. Well, technically, legally, reasonable doubt's a higher standard, but it's an undefined higher standard. And look, if anything else, it means what it says. Beyond a reasonable doubt. Is there a reasonable doubt she didn't do it?
Not if she walked in with a pan in her hand.
Fair enough. Fair enough. Let's see. Mr. Holland, what do you think?
I would probably stand with that unless other evidence was shown that someone else could have been in there or had reason to do it.
Maybe somebody could raise a reasonable doubt. But absent that, gotcha. All right. Let's see, Ms. Brown. How about you?
I need more details.
More detail?
Yes.
Okay, what kind of detail are you looking
I
for?
mean, you say she went in with the pan, went and came out with the pan.
It came out with pain.
I need other details.
What are the details? Like,
I don't know who was in there with her, who else was in there with her.
what if she said, yeah, I hit him with pain? Would that be enough?
No, need more details.
Even if she admitted it? That's not enough for you?
I love me.
Okay. All right. I got it. I got it. Let's see, is it? Mr. Cash. How about yourself?
I would say it'd be like a combination between her and him. You saw the fact that she went in there with a pan, you saw the guy go in there with a knife, and like he was saying, it's dark, so maybe somebody else could have been in there, but you would have to prove that there was somebody else in there if you could do that. But more than likely, like she said, she came out with a pan, so obviously she did it.
Right, well, how about you?
Prove that somebody else was in there.
So Ms. Brown raised an interesting thought. I asked her, well, what if Marion admitted, yeah, I hit him in the face with a pan? Would that be enough for you?
More than likely, yes, unless somebody else said that they was in there too.
Unless somebody else said, no, Marion's
Yeah.
lying, she didn't hit him with a pan,
Yeah.
I hit him with a pan.
Yeah.
Okay. I got you. Is it Sonia? Oh, yes, ma'am.
Okay, you said my name, and the reason why I said that, I mean, I don't know, somebody have, I don't like to say, I don't know who in there, somebody can have a gun to her head
Oh.
and making her say that.
I got you.
I just want to let you know what
Okay, I'm savvy now.
Okay.
Like, you say somebody may be, so there may be another bad guy in there, like,
Yeah.
saying, you say you did it, or
I
I got your kid, or,
Okay.
hostage or something, right? Okay. Oh, I got you.
Okay.
All right. This clears it up for me. Mrs. Sonia.
Yes, sir. 4 ounces of that, sir. Excuse me, you on? Everything. I
You gotta go what?
need to go to the restroom.
Oh,
Okay,
Yeah,
you can go ahead on.
okay.
I just stopped the clock.
Okay.
I just stopped it.
okay, thanks. What have we got, 10 minutes?
No, you got 15.
Oof. Oh, yeah, just, Judge, can we ask, if
Hold on, hold on,
if
hold on.
anybody else needs a break, maybe this would be a good time.
Hold on a minute. Hold on a minute. Put this on. Does anybody else need? Okay. All right.
We also stand up
Mr. Hammond, you may resume. You have 15 minutes, 8 seconds.
Thank you, Judge. I forgot to say before, but thank you to all the remaining people, because I can't decide whether or not this defendant's guilty or innocent. We certainly couldn't. The justice system, which I believe is still the greatest in the world. It's not efficient. It's not quick. It's not inexpensive. Still the most fair in the world. And not one person deciding guilt or innocence. And we could do this a lot cheaper and easier, but we don't. Thank you. Mr. Son, am I right on that?
Yes.
Okay, well, first of all, thank you very much. I enjoyed it. We appreciate that. So we were talking about Marion and reasonable doubt, and if I had proven her guilt of, hitting the bad guy in the face with a frying pan beyond a reasonable doubt, with just that evidence, what do you think?
That's a hard one for me. I would need more.
And when you say more, what are we asking for here?
Well, she runs in the dark home with a friend. He runs in there with a bank. We need a bank. But we don't know if someone else is in the room. We went to this before, and I just don't, I don't think I can make it that way.
But what do you think about Mr. Holland's comment about, well, if that's all the evidence that was presented, and there was no other reasonable excuse for what happened, then I could find guilty. How do you feel about that?
I still think I can.
No. Okay. I got it. Let's switch a little bit to the case, general case. I can't talk about the specifics of this case, okay? The jury's gonna see the specific facts, but we know it's a DWI trial, right? We can at least talk about that. So, Mr. McKinney, DWI, what are you looking for? What evidence do you want to see before you decide whether or not somebody is intoxicated?
Depending on the substance, a blood alcohol test will say
So
legal limits.
you said blood alcohol test. Well, what else would you use to make up your mind if somebody is intoxicated?
Their behavior, if it's not normal.
So, all right. That sounds like you're bringing in your own personal experiences to this deal. You said normal, right? So, have you ever seen somebody who's intoxicated? I mean, like more than once? More than twice?
Way more than.
All right, way more. All right, so what are you seeing when somebody's intoxicated? What are you seeing? Like, what are you looking for in their behavior? You said not normal behavior. What can you articulate that a little bit?
Well, just from my experience, we've dealt with people who've been high on drugs.
Okay.
They run around, they're hallucinating, yelling, screaming, just not acting their normal self.
Okay. And that, in fact, is part of the definition of intoxication, right? Loss of the normal use of your mental or physical faculties. In this case. Okay. Have you ever seen someone who you believe to be intoxicated? And what was it about their behavior that caused you to think they were intoxicated?
Slurred words, being obnoxious.
So, is Ms. McCarty? McCarty, am I right? Okay, McCarty, how about yourself? Have you ever seen somebody intoxicated?
Yeah.
Okay, and what were some of the clues that clued you in that fact?
Probably slurred speech. I guess I think there's a difference between drunk and being high or being on drugs, but when I see people that are drunk, like slurred speech is kind of show that they've been at
don't know, it's evidence more than just knowing how many drinks they had. Also not being able to stand up straight or like missing things, like missing a door. Like walked into a door instead of opening. If it's drugs, I think it's harder to tell, other than them not being themselves without what their normal behavior is typically.
So, I mean, you can use your experiences. Are you telling me you can use your experiences and view somebody and go, yeah, I think they're intoxicated?
I think, from alcohol, from drunk, yes, I think I'm pretty good at understanding when somebody is intoxicated. Like drugs, probably not so much unless I have an understanding of it.
Mm-hmm. I got you. This Christian. Christian? How about yourself? What would you look for in a DWI trial as evidence to prove intoxication?
I would like to see the blood alcohol level, and I would like to see any body cam or any, film that there might be.
Okay. Yeah, fair enough. And if you were watching that body cam, what would you be looking for?
Any unusual activity. I personally have seen people who I knew were intoxicated and acted absolutely normal.
Okay.
So I would have to have real evidence of intoxication.
And what do you mean by real evidence?
The blood alcohol level, maybe witnesses from the amount of alcohol that was consumed.
Okay. Got you.
Mr. Ham, you have 8 more minutes.
Thank you, Your Honor. That's right. How about yourself? What evidence do you want to see in a driving while intoxicated trial?
Blood test, if it's that.
Okay. What if a blood test isn't?
Obviously want to see the footage at the time of the arrest. Talk to, again, witnesses. I agree with everything that Mr. Christian's saying. Witnesses that maybe saw the behavior prior to the arrest. It's hard to determine if something is not normal behavior because again, you don't know this person in the role that we're serving, so you can't really judge by paper. So yeah, anything that is.
Could you look at all the evidence and take it into account when making your decision, Mr. President?
Yes.
Yeah. All right. Go ahead and skip ahead. We're running out of time. Obviously, look, we're here to try to render a fair trial, right? We want to put on a fair trial. All right, defendant has the right not to testify. That's a constitutional right. You can't hold it against her if she doesn't. She has a right to remain silent. She has a right to counsel, Mr. West. She has a right to a jury trial. She has a presumption of innocence. Again, there's been no evidence put on here. She's innocent unless she's proven guilty. She has a right to subpoena power, subpoena witnesses, or she has a right to testify if she chooses. Okay, but either way, can't hold it against her. All right, skip ahead. Let's talk about witness credibility. All right, Miss. Oh. You know any police officer? Okay. If we had a police officer come up here and sit on this witness stand and testify, is that man or woman going to start with more or less credibility than your average citizen? Why? Okay. Well, let me ask you. They have some experience. As a juror, could you listen to a police officer testify and make your own decision as to whether or not you find that person to be credible or not? You can. Okay. Good. So So for you, maybe they start with a little bit more credibility because they have a badge. Does that automatically make them credible to you, no matter what they say? Are you gonna believe them?
Also, I'd like to see if there's a toxicology.
Like, see if there was toxicology, that would be important to you. I understand. Mr. Cash, police officer, do they start out with any more or less credibility than any other person for you?
5 more minutes.
Well, yes, because they deal more with than us so-called normal people and everything. So yeah, I would put it a little bit higher than us, yeah.
Well, could you listen to that officer's testimony and then decide after listening to it whether you find it believable or not? Even if they have walk in with a badge, you're not just gonna believe anything they say, right? Okay. I'm with you. And that's kind of that's all I'm trying to get at. Look, if you're on the jury and the witness comes up here, no matter what they look like, I mean, you can take into account what they look like. You can take into account everything about them if you want. But wait until they start testifying, to start making up your mind whether or not you believe them. Just because in this trial, we put police officers up there, okay? Be your own judge of their credibility. They should all start off with the same level of credibility. All right. Mr. Richard, do you believe DWI is not, well, can you see all that? You can't see it? All right, look, it's list number one. It's like, let me just ask it this way. Look, we're gonna skip all this to run out of time. Do you think DWI is a problem or not? A problem?
Yeah.
Why?
Well, people could get injured, killed.
And
It was others somebody being intoxicated.
let's see, Mr. Alvarez, what do you think? Is DWI a problem?
Yes,
Why?
it's because it's happened multiple times, all the time. People always killing somebody, hitting somebody. It's an ongoing problem.
Just like that, right? Yeah. Cars are dangerous objects, that's for sure. Okay. Is there anybody here, and please just be honest, is there anybody here, well, first of all, does anybody have anything that they feel like they need to tell us that we haven't talked about, that you think would affect your ability to be a fair and impartial juror if you were called to serve in this case? Does anybody know Mr. Williams? Anybody know the defendant? I don't think anybody knows me. How about Mr. Coleman? He just came from Livingston, so probably not. Okay. Is there anybody that, for whatever reason, believes they could not be a fair and impartial juror in a DWI case? Thank you again for your service. I appreciate it very much.
Mr. West, the panel is yours. You have 30 minutes.
Thank you, Your Honor. Good afternoon, everyone. First thing I'm gonna do is thank you for being here. I'm gonna reiterate Mr. Ham's thank you on that. And who here thought this would be like Matlock or Law and Order or something like that? And they don't show you sitting out in the hallway and the waiting and the bathroom breaks and all that. So, and I thank you for bearing with us on that. I assure you, there's gonna be a lot more of that for the 6 of you to get on this jury and the alternate can do it tomorrow as well. And as far as interest, Mr. Hand, a little quick interest, I think it's kind of right for me to do one too. Although we're both attorneys, a little bit different when it comes to this court field. I'm from Southeast Texas originally, been there all my life, except for the period of time I went to school. And I've been, Mr. Ham kind of had different jobs leading up to being an attorney. I've always wanted to be an attorney, and I've been one for this May will be my 22nd year. So this is what I've only done. This is the only job I've ever had. This first part here is called the void hour, like they said. This is where we get to talk to you guys and see who's the right person for this jury. Like I said, like Mr. Ham said, you might not be right for this jury. We all have bias, we all have prejudice, we all have things about us that make us who we are, okay? I'm gonna give you an example. I like to use examples to make my points. Who here remembers President Bush, the senior, the older, the first one? Everybody, okay. There was a particular food that he did not like, and he came out and said he didn't like it. It kind of made a little uproar. Does anybody remember that food? Yell it out loud if you remember it. Broccoli, okay. I'm always afraid that a jury is not going to know that. I've actually had one jury up in Newton one time and nobody answered that question. Absolutely. And I always get yelled at court reporters for talking too fast. Yeah, President Bush came out and said during his presidency that he didn't like broccoli. And the farmers kind of said, wait a minute, you can't say that. Don't say that. He was like, yeah, I can say that. I can do that. It's my right. It's my personal preference. Who here doesn't like broccoli? Anybody? Everybody likes broccoli? Okay. I have a 3-year-old that doesn't like broccoli, so I fight with that. Now let's say today's trial was not about DWI, but what the state vegetable of Texas should be. Let's say on one side we have, I don't know, potatoes. On the other side we have broccoli. Let's say we had President Bush here, and I know he's passed away, but let's say, just for argument's sake, he's still with us, and he's sitting on this jury. Who here thinks he would be a good juror for that case? Raise your hand. Huh? Ms. Joffrey, why not? Or why?
What is your question again?
Do you think he'd be a good juror for that case?
If you have, repeat what you said before that.
If our trial today was not about DWI, but it was about what the state vegetable of Texas should be. Let's say we had a trial about it. One side was potatoes, and one side was broccoli. Would he be a good juror?
He would probably say he didn't like broccoli.
So he would not, or would not be a good juror. Okay. Ms. Let's go back on. Mr. Alvarez, will he be a good juror for that case?
I don't think you would.
Why not?
Because he's like, if you're going based on his public, he already stated that he doesn't want broccoli.
Right,
then why
right.
would we put?
He's already got an opinion he's very adamant about it, and he's got a bias, prejudice, whatever you want to call it. He's got his mind made up, doesn't he? Right? Is he qualified to be on this jury? Yeah, he's a Texan, right? Yeah. He was the leader of the free world, whether you agree with his politics or don't agree with his politics, doesn't have anything to do with this. He's qualified to do it. But he has a bias. He has something about his life that says, no, I'm not good for that. And that's why we're asking questions and find out things about you to say, I'm not really good for this. Who here thinks they are fair and impartial? Raise your hand. Who doesn't think they're fair and impartial? Raise your hand. I need to know those people, okay? All right.
We're all like sometimes not fair and impartial.
Because you have bias and prejudice but with your personal life, correct?
Right.
That's what I'm getting at. That's why we're asking you questions. That's exactly why we're talking today, is to find out things about you, to find out, might be good or bad about that. Who here, for example, has ever had their house or their office broken into? I have. Right? Let's say the trial is today about a burglary of a building. Those people that raise their hands probably wouldn't be good for that trial because you have a personal feeling about that, right? Okay. So that's why we're talking about this. Let me just ask you a question. Who here has been arrested for, pulled over for, or stopped for DWI? Anybody? You see why I would ask that question? Because that would be pretty relevant here, right? So that's why we're doing this today, is to find out if anybody has a broccoli, so to say, something about them that they're very opinionated about or have a strong feeling about, or something about this case that makes them go, nah, I'm not the right one to be on this case. Give me something else. Give me another kind of case. Okay. All right. Let's talk about some legal theories, and Mr. Hams touched on some of them. I'm going to go over some more with you. Who here has heard the phrase "innocent until proven guilty"? Raise your hand. Okay. And then I always pick this apart when prosecutors get here and say that. Mr. Hams did not say that. You heard him say that earlier. He said innocent unless proven guilty. There's a difference there, but that's one of the first concepts of our criminal justice system, is that everybody's innocent unless they're proven guilty, and the state is the one that has to prove them guilty. Okay. Why do we have that in our system? I'm going to talk right here, Mr. Holland. Why do you think that's in there?
I would believe they would have to prove their point.
Right. It's to keep innocent people from getting accused of something. You got to remember when our forefathers created this law or this rule, They were coming from a monarchy who basically, when the king said you're guilty without any kind of, defense. You couldn't say anything. He said you're guilty. That was it. They wanted to make sure our system would not be that way. So they put in there that every defendant is innocent unless the state or the government proves them guilty. Okay. So with that concept in mind, let's say we had a vote right now. Okay, and here's your 3 votes. I'm gonna give you 3 votes: guilty, not guilty, I need more evidence. Who here would vote that my client is guilty right now? Raise your hand. Okay, who here right now, if we had a vote right now, would say not guilty? Raise your hand. Do we have more? Who here would say, I need more evidence? Raise your hand. Okay. And surprise, surprise, being an attorney, it's a trick question. There was one right answer. Okay, Miss McCarty in the back. Why did you say not guilty right now?
Because if we have to make a decision about what the consequences are going to be for somebody's life, there hasn't been any type of evidence, or there hasn't been an argument that's proven that she's guilty.
Exactly. Because you're innocent unless proven guilty, and there's been no proof given at all yet. Mr. Hamlet hasn't even put on the evidence yet. The case proof hasn't even started. So as we sit here today, my client remains innocent unless they can prove her guilty. Okay. Now let's talk about beyond a reasonable doubt. Mr. Ham talked about that, and like he said, there used to be a definition, and like I said, I've been doing this for 22 years, almost 22 years. And when I first started doing this, there was a definition. We literally just read it to you. Said, here's what beyond a reasonable doubt means. And later, the Court of Criminal Appeals came back and went, no, you're not going to do that. You're going to let each individual make up their mind on what that is. So I really can't tell you what the definition is, but I can give you some examples. So I got a couple of examples. Who here has heard of the burden reasonable suspicion? Not a lot of people have heard that before. That's the burden an officer needs to detain you for questioning, and it's more than a hunch or guess. Okay, and I'm going to give you an example. Let's say during lunch today, there's a bank up here, by the way, it's the employees' bank or whatever, it's right around the corner over here. Let's say that bank was robbed, and all the officers know that the bank got robbed, and be on the lookout. And the person who robbed the bank was about 6'2", has a beard, wearing a dark gray suit and purple tie. He over there have a reasonable suspicion to go, John, come over here a second. Let's talk, buddy. Yeah, because more than a hunch or guess, he's got some description that matches me. Okay? Doesn't mean I did it. Doesn't mean I'm guilty of it. It just gives him the reasonable suspicion to go, hey, come talk to me. Okay? Who here has heard the phrase probable cause? This is more common. Yeah, if you've seen legal TV shows, you've probably heard this phrase. That's when a police officer needs to make an arrest or search. Okay, it's a little more moving up. Let's say as he's talking to me, he notices my bag. My bag's sitting right over there. It's kind of open, and as we were talking, he kind of looks down and sees a bunch of $100 bills and random denomination bills and everything kind of stuck in my bag. Now, does he have probable cause to go, John, what's in your bag? Let me take a look at that. Pull it out. Let me see what that is. Yeah. He's got probable cause. I matched the description. I got cash. Again, doesn't mean I'm guilty of this. I could have been paid by a client right before court, and they came in and paid me some money. They might have robbed a bank. I don't know, but I didn't. Okay. So that's kind of different versions we're moving up of what level you need to prove stuff. Okay. The next is a phrase, and somebody used this earlier today. I think Mr. Bright used this phrase: preponderance of the evidence, more likely than not. Did you use that phrase earlier? Okay. That's what's called preponderance of the evidence. Who here has been on a civil jury before? Raise your hand. Yeah, that's what you need in a civil jury to take property, take money, those kind of things. Just more likely than not, they get the whole thing about a scale of justice, and if you tip just one way slightly, or a football field right down the middle, or whatever description they can give or example they can give. That's what that is. It's more likely that happened than this happened. That's not what we're here today on. We're still here on beyond a reasonable doubt. Now, there's one more burden up this level here. It's called clear and convincing. Have you ever heard of that? Clear and convincing? Okay. It's not really a common one. You don't see on TV or hear about it or all that. But that's what's primarily used in child custody cases. I was just on one of those this morning on a Zoom where they're trying to remove a child. Who here's a parent? Raise your hand if you're a parent. Okay. Out of those people, who here thinks your child or children are the most important things in your life? Raise your hand. Everybody raise your hand first time, yeah. I'm 47, have a 3-year-old. I started late in life, but my little one's the world to me. I'm sure all the parents feel the same way. Clear and convincing is the level the state needs to take your kid away from you, to remove your kid, okay? It has to be clear and convincing. But that's still lower than beyond a reasonable doubt. Reasonable doubt is the highest one in our system. It's way up there. It's more than what an officer needs to talk to you, to stop you, to detain you. It's more than an officer needs to arrest you or search you. It's more than what is needed to take away your money, your property. It's even more than what's needed to take away your children. What everybody just told me, raise your hands on me, the most important thing in your life are your children. And the reason why is because our government feels that taking away your liberty, your freedom is the most important thing that you have. And this is the harshest that they can take away, okay? So that's the burden the state has to prove in this case, beyond a reasonable doubt, okay? All right, let's talk about another legal concept that we're going to be dealing with today, right to remain silent. I'm just going to pick some people out here. On the blank, like we're missing. Mr. Bigelow. What does right to remain silent mean, just basically?
Right, not to say what you want to hear,
And why not?
because it's not right.
Okay, and in the legal system, it even goes back to another concept that we already talked about. Because you're innocent unless proven guilty, right? Okay, they all kind of tie together here. You don't have to say anything because we on this side, what do we have to prove?
That you gotta prove me that I did something.
Anybody
On
on
this
this
side,
side? You know,
that I didn't do something, I'm sorry.
nothing, exactly. We gotta prove nothing over here. Because the burden to prove this case beyond a reasonable doubt is on these guys. Okay? So if we sit here today and we don't say anything, now I guarantee I'm going to say stuff, but let's say I didn't say anything. Let's say I just sat quiet and didn't say a word. And they failed to prove this case. Who here would still find my client not guilty? Exactly. Yeah, that's the burden. They don't prove it, it's not guilty. Right? Now, who here says, no, I want to hear your client talk? Raise your hand if you feel you want to hear my client say something. It's okay. I mean, it's not. Anybody? Nobody? Okay. All right, let's get some easier questions. Is anyone here a police officer or in law enforcement? I would have somebody to talk to, but anybody else here? I looked at those information sheets and I got a feeling for most of you guys that I'm get you. I know you. Anybody else here? Okay. In the back there, Ms. McKinney, you work for the Federal Department of Corrections, correct? All right, is that the technical name of it, or?
Bureau of Prisons.
Bureau of Prisons, okay. There's all these different names, they change, it seems like all the time. Okay. Based on that, is that going to affect how you listen to this case today and tomorrow? All right, does anybody here have a close family member that's in law enforcement? I'm not talking about a cousin or uncle, where I'm talking about, mother, father, brother, sister, kid. Okay, we got some? Okay, let's start with this second row here, the first row here, Mr. Bigelow.
I've got a daughter, police officer.
Okay, daughter's police officer, yeah. That kind of goes to one of the questions that Hannah asked you. If a police officer comes in here, are you going to give them more credibility just because they're a police officer, or are you going to listen to their testimony?
I want to listen to the testimony.
This next row, anybody? Yes, at the very end, Miss Christian. Who do you have?
Not presently, but my husband was in law enforcement for 41 years. My son was in law enforcement for 21 years.
Okay, all right.
Mr. West, you have 15 more minutes?
Okay. Same question I just asked Mr. Bigelow. If an officer comes in, there's going to be something tomorrow. Are you going to give them more credibility just because they wear the badge, or are you going to listen to what they have to say?
I'm going to listen to what they have to say.
Okay. And you of all people should know that just because they're officers, I mean, they always tell the truth, because you had a son that was a law enforcement officer, correct? Okay, and I'm sure growing up, he always tell the truth, and he sometimes do some bits here and there.
That particular son.
Oh, he was the good son, okay. But you get my point here. I was a good son too, so, Next row, anyone? What about that back row? Okay, who else do you have, Miss McKinney?
My stepfather.
Okay, police officer or? Same question asked before, same ones. Are you gonna give officers any more credibility? Okay, great. All right, let's talk about DWI a little bit. Mr. Ham put up on the screen kind of the definition of what the DWI was. It's basically comes down to not having a normal use of mental or physical faculties. Okay. I'm gonna jump back to the front. Mr. Alvarez. Normally, if I'm picking a jury of 60 people, I never come back to the front. Back to you again. What is normal use of mental or physical faculties?
I mean, able to, I guess if you're physically able to walk correctly, speak correctly, without slurring.
Let me ask you, are your physical faculties and mental faculties the same as mine? Oh, well, we don't know.
Yeah.
Maybe. That's my point. We don't know. Okay. And I think some people talked about that during Mr. Ham's statements. Everybody's normal is a little different, is what I'm getting at. Is that fair to say? Right. So without knowing somebody's normal, we don't know if they're not normal, right? Anybody disagree with that statement? We understand what I'm saying here, that everybody's normal is different. And without knowing somebody's base and normal, we can't know if they're not normal. Okay. Let's get some of these. We're gonna have some officers testify. Which ones are gonna testify?
Yeah, the officers, Hanley and Garcia.
Okay. Does anybody here know Philip or Felipe Garcia from BPD? What about Stuart Hanley? Okay, I didn't think so. I just want to make sure. And again, everybody's already been asked this question, but nobody knows me, correct? I don't recognize anybody out there. And nobody knows Mr. Ham, do they? Raise your hand. Or Mr. Coleman? All right. Now I'm going to go to just some specific questions based on your jury information sheets. Like I said, we get to look at these ahead of time. Normally, I have a lot of questions off of these, but you guys did a really good job filling these out. But there was one, two. And Mr. Is it Sonia or Sonia?
Sonia.
Sonia? You put in your as your occupation, the job that I'm currently, because I've only been an attorney, the only other job I want is what you are right now, which is retired. That's my next job after this one, okay? Still got some time to do, but what you did before you retired?
I tried it out.
Okay. And some other people are also retired jobs, so they did kind of what I did before, so I don't need to go into that. That's the only one I had on that. Another thing I want to do right now, because this is our real time that we can talk like this, is I want to apologize for the 6 of you guys to get selected in the alternate. We may appear to be rude tomorrow to you, okay? What I mean by that is if you get on the elevator and I'm walking up, I'm not going to get on the elevator with you. If you're down in the kitchen or the cafeteria downstairs, the kitchen they have down there, getting food, I may stand back at the door and wait till you finish your food and walk away. If we happen to be at a restaurant and you're sitting at a table and I walk in tomorrow during lunch and you're there, I may turn around and walk out, okay? It's not that I'm trying to avoid you, well, I am, but I don't want to avoid you. I'm having to avoid you, okay? I don't want anybody to think there's some kind of inappropriate things going on that we're talking, okay? So that being said, the reason I say that is number one, to apologize, but number two, to set up this next question I have, the final question I have.
You have 10 more minutes.
I only need about 3. Whenever I sit down in a moment, we're not going to be talking for. We're going to be talking to you the rest of this trial, but you're not going to get to talk back. You just got to sit there and listen. This is our last time to have this interaction back and forth. That being said, is there anything that's your broccoli? Is there anything about this procedure, this trial, this defendant, me, Mr. Hand, anybody that you're like, well, I need to tell you about this? It might make it. Does anyone have anything you want to say? kind of a catch-all question. You know what I
I
mean?
have something, I
Yes,
almost
yes.
said it earlier, with Mr. Ham. So I can understand the law, and I think I'd be able to practice the law. But I don't necessarily know how to feel about the .08 thing, because it does affect different people differently. And so I just have to say that because like, it has always kind of bothered me. I don't know like what the scientific evidence there was to establish that number. I'm fine with like bullet points 1 and 2, but I do have some concern about bullet point 3, just from a personal standpoint. And I don't drink, so it's not that, it's that I've seen 2 drinks affect somebody very differently than someone else.
Absolutely, and you make a good point right there. You don't drink regularly, right?
No.
Right? I don't drink either, and I'm sure if we had drinks, 1 or 2 may affect us differently than somebody who drinks every day, right? Even though our BAC probably would not be 0.08, we would be intoxicated, correct?
Right.
Right? And that's something that the jury's gonna have to evaluate and determine as part of what, that's why we have a jury, because like you said, if it was easy, we wouldn't need a jury to do this, okay? Does that make sense to everybody? That's the reason 6 you're gonna be on the jury to evaluate those points, exactly, and determine whether these facts show that this person was intoxicated or not. Anybody have anything else I want to say? All right, well, let's go to, oh, yes, yes.
This one administrating, do with the trial, but I think it would be, disservice to the, lady,
Ms. Neal.
I'm a diabetic.
Uh-huh.
And sometimes I might have to excuse myself.
Absolutely.
I think it would be an injustice to the panel.
Well, if you make it on the jury panel, I'm sure like you did earlier, just raise your hand and stop one of us, because it's gonna be me or him talking. And we'll pause and trust us. We get going, we don't think about it, but we like when people stop us sometimes and take a break. So if you're one of the 6 and you need a break, I'm sure the judge would agree, just let us know. You take a break. Okay. Anyone else? All right, thank you very much.
Okay, ladies and gentlemen of the jury, we were going to ask that each and every one of you step outside into the hallway. Now, we may have to call some of you back in to do some follow-up questions, but in the meantime, just follow the bailiff, have a seat in the hallway, and if we need to call some of you back in, we will call you back in. Yeah, you can go out both doors. Just wait till. She's gonna sit right there. Oh, hold on a minute. Let the record reflect that the jury panel is not in the courtroom. However, we do have in the courtroom State Assistant District Attorneys Blake Ham and Tommy Coleman. We also have Miss Pamela Neal, who is the defendant, and we have her attorney, Mr. John West. At this time, does anyone, well, start off with the state. Do you have any people that you would like to brought back in for questioning for challenge for cause?
I don't know that we have any questions for him unless the court wants to bring him up. It's juror number 14, Mr. Saunier.
14?
Yes, sir. He indicated that he doesn't think he can make a fair judgment, Your Honor.
Okay. Yeah, okay. Anybody else?
Well, and also, he also indicated that he couldn't follow the beyond the reasonable doubt
Okay.
standard.
So-
In his words, he said he need more than beyond a reasonable doubt.
Okay, so the state want, is that Joseph Jean? I think he said Sonia. Saunier. Okay, now, Mr. West,
I don't have any.
you don't have any? So at this time, we're going to, Mr. Bailey, call in.
Can we agree to strike for cause?
No, I'm gonna have to bring him in.
Okay. Won't you call in Mr. Joseph Jean Sonia? And I'm gonna-
He said, I don't think I could make a fair judgment. Are my notes correct?
Yes.
And you also indicated that, according to my notes, you said you needed more than what's required under the beyond a reasonable doubt standard. You'd want more. Is that fair? Did I get that right?
Yeah,
Okay, thank you, Mr. Sonia. That's all I have, Judge.
Okay, Mr. West?
Just a couple questions. When you say you couldn't be fair, what do you mean by that?
well, I mean, I could be fair, but it all depends on the evidence, you know, I mean, if I would have to have, you know, from what, we all talked about the pain and stuff like that.
Yeah.
There wasn't enough evidence to be. Now, had I had more,
Okay.
it, you know, it might be different.
But you can evaluate the evidence and make your decision based on that evidence and make a fair decision based on the evidence that you have in front of you.
Yeah,
Okay.
yeah, I think I could.
Okay. And when you said beyond a reasonable doubt, if they established evidence beyond a reasonable doubt, you could find a defendant guilty, correct?
If they found it beyond a reasonable doubt.
Okay, so your issue is not that you can't be fair, is that you, in the scenario that you were given, you didn't think there was enough.
Right.
But you're willing to listen to the evidence and make your evaluation based on the evidence.
Yes, yes.
That's-
Okay, Mr. Coleman?
I have nothing further for Mr. Sonia.
Okay, Mr. Sonia, you can go have a seat back out in the hallway.
Mhm.
And thanks for taking time out from your busy schedule to be here.
Thank you, sir.
All right.
The state would renew his challenge because he specifically said, regardless of what he said here at the stand right now, he specifically said during the court hour that he does not think he could make a fair judgment in this case.
And I think, Your Honor, I talked to him a moment ago. I think that was based on the scenario that Mr. Ham gave him, that he didn't think that he could be fair based on the evidence he was given there. And I think he said here, he can listen to the state's evidence and make a decision, a fair decision based on that.
Okay, so your challenge for cause is gonna be denied.
Thank you.
All right. At this time, let's see, we'll give each side, how much y'all need, about 10 minutes, 5-10 minutes? Okay. Who's gonna use the jury room?
Take the jury room.
Okay. All right, we'll be in
Thanks, sir.
recess. All right.